My task is pleasantly brief and a joy, namely to introduce Elham Saudi, tonight's moderator and director of Lawyers for Justice in Libya. Elham is a SOAS alumni, and the organization Lawyers for Justice in Libya is a true child of SOAS, founded by Elham in those heady days of 2011. Since then, the organization has weathered a number of storms and has, under Elham's leadership, established itself as the foremost NGO working on human rights, justice, and the rule of law in Libya. Given the challenges posed by working on and in a country such as Libya, tonight's lecture is a timely inquiry into the meaning, scope, and limits of justice in such environments. We are privileged to have an organization such as Lawyers for Justice in Libya to provide us with insights into their valuable and excellent work on these issues in the course of the evening. Elham will introduce our speaker, Pablo de Greiff, but I briefly want to take the opportunity to make a few personal remarks. Since I first met Pablo in the mid-2000s when working for Redress, I've come to admire him both as a wonderful person and as an engaged scholar. He has throughout his career combined theoretical and philosophical thinking with practical engagement, grappling with highly complex conceptual and political challenges. It was therefore entirely appropriate that he was appointed the first United Nations Special Rapporteur on promotion of truth, justice, reparation, and guarantees of non-recurrence in 2012. A very long title. I take it that they wanted to avoid the word transitional justice in it. During his time as Special Rapporteur, he demonstrated what an inspired choice he was. He worked tirelessly and excelled in putting the newly established special procedure on the map, framing the mandate, identifying, clarifying major issues, visiting key countries, and engaging with a broad range of actors. And I take the memories are still fresh for you. I couldn't have wished for a better speaker tonight, and I'm very happy that you are able to be with us tonight, Pablo. Before I hand over to Elham, a couple of housekeeping points. Please make sure that your mobile phones are on silent. Also, in the unlikely event of a fire alarm, please take that seriously and leave the room immediately following the exit signs. But we are not talking about any exit or end of the event because we are just at the beginning, and it's my pleasure now to hand over to Elham to introduce and talk you through what is in store. Thank you.
Thank you, Lutz, for that introduction. Lutz is the director of the Center for Human Rights Law here at SOAS, and my ex-lecturer and supervisor of my thesis, and so it feels very odd to be on stage with you in the audience, and this dynamic is very odd for me. As Lutz said, LFJL started at SOAS, so it's a real source of pride that we're back here 8 years later as a partner of SOAS on what we hope will be a regular fixture in the calendar. In these 8 years, LFJL has done a lot of work. I would even say some of it was very good. But I think one thing that we brought, which is a source of real pride, is an innovative approach to working in a really difficult context. By way of example, we had to respond very quickly to things on the ground when the revolution, uprising, whatever you call it, started in 2011. Key amongst them was trying to train people on the rules of engagement and how to fight in a legal, quote-unquote, way. We texted the rules of engagement to every mobile phone in Libya and were able to get the information out quickly in a very difficult time. We also conducted the widest ranging tour of the country to talk to people about the constitutional process and to genuinely engage them in what we think is a very vital and crucial process to Libya. Our anti-torture work was also sensitive to the victims, which is something we take a lot of pride in. Whenever we work with a torture victim, we ensure that we also take care of their rehabilitation as well. So that is a really key part for us, is that we acknowledge that the legal process is unsatisfying sometimes and is very long all the time, and that it's important to help people along the way. Now our work is more sort of programmatic, but it's still responsive and it's still innovative. At the moment, just by way of example, we're working on tracking drone attacks against Libyan civilians by third parties. We've established an archive that allows those working on the ground to safely store their evidence digitally, so that if it gets destroyed physically, at least it's not lost to the record and to history. And more recently, we've launched a project on increasing victim participation at the International Criminal Court. But being responsive is not easy, and it requires agility and the ability to move quickly. And with that, we face some challenges. The security and the personal threats are the ones that are most commonly talked about, but those are the ones that sort of come with the package. The other challenges we faced have been really difficult, and key amongst them is the resources that we face, the constraints on our resources, whether that's human resources or whether it's financial resources. I won't go on about our work, but I thought it would be important to introduce us. If you'd like to know any more about what we do or how you could support what we do, the smile at the end, you can talk to any of the LFJL staff afterwards at the reception. Please join us and do talk to us. One of the things we reflect on a lot at LFJL is what we mean by justice, not least because it is in our name and it is what we say we work for as an organization. And when we think about it, we thought actually what would be really interesting is to have these series of lectures that gives us an opportunity once a year to just take stock, step back, and really reflect on what this term means that we use so fluently. And what we wanted to explore is how do we define justice, how do we operationalize justice, and how do we test justice? And when we thought about this important first lecture in this series, the choice was easy. I mean, this was one of the easiest choices we've ever made. Pablo is a no-brainer for this. In addition to him being the UN's first Special Rapporteur, and I have to say it is a very long title, so I have to read it, on the promotion of truth, justice, reparation, and the guarantee of non-recurrence. He's also the Senior Fellow and the Director of the Transitional Justice Program at the Center for Human Rights at the School of Law at NYU. But aside from that, I genuinely feel that he is the most nuanced and comprehensive thinkers on the question of justice in the context of transition. And in addition to being a cerebral thinker, he's also passionate, which is such a rare combination to find in people working in the field. You often get one or the other, but finding the two together is really incredible. The fact that he said yes when I asked him is a personal career high that I will not come down from for a very, very long time. And the fact that I got to have his pleasure over lunch today and really pick his brain makes this event sort of indifferent to me now because I got YFix. But also, I think what's crucial about Pablo is that he is not someone who is involved in the Libya situation. And for me, what we need now is just, as part of these lectures, we'd like to take a step back and have a fresh perspective and a reflective conversation about this. And sometimes we who work on the question of Libya day to day lose that perspective, and I think it would be good to have that probed a little bit. For the topic of the first lecture, we wanted to reflect on the context of justice in what people increasingly are calling a failed state. We hear it a lot. Politicians, in country and out of country, refer to Libya as a failed state. The media often refers to it as a failed state. You'll see most recently last week a very good article in the FT describing Libya in that way. And donors often also limit their involvement in Libya by declaring that it's a failed state. And often the term is used really to justify relegating work on justice to a lower priority. And that's the danger of that terminology. And so I won't go on, but it's my absolute pleasure and honor to welcome Pablo to the stage.
Thank you very much, both to Lutz and to Elham for extraordinarily kind and undeserved introductions of the sort that almost guarantees that what follows will be a disappointment. So I appreciate it immensely, and at the same time, it makes me apprehensive. I remember in an entirely different context with a government official in a country that I visited who was not particularly keen of having to talk with me, started criticizing what he called the transitional justice industry. And then he said, and you are the CFO. And he did not mean that in praise. So thank you very much. I appreciate this extraordinarily. I also want to acknowledge the very impressive work that Lawyers for Justice in Libya are doing. I have been very by what you have accomplished and what the plans that you have. So it's an honor to be here, and it's an honor to be here at SOAS. Last time I was here, as a matter of fact, I was reminiscing today, was after the mandate had been established by the Human Rights Council already, but before anyone had been appointed to the position. So it's very nice, a sort of bookend experience. I came here before I assumed the mandate, and now I am back, having been done. So I appreciate it immensely. The fact that someone wants to invite me again after the 6 years tells me that perhaps not all the efforts were wasted. So thank you very much. I am delighted to be here. Thank you very much for being here. I was asked to make some remarks, and then we will engage in a conversation both with Elham and with all of you, so I do not want to extend myself too much. I will divide my remarks into 3 different brief sections. The first one is an introduction, just to set a bit the terms of how I understand the term transitional justice, so that we make sure that we are talking about the same thing when we use a term that, of course, is very heavily contested. It has porous borders. What it includes and what it excludes is still a question of debate. So I just want to give you my understanding of the term transitional justice. In that first section, I will always say a few things about what I think the field has accomplished during its relatively brief existence. I remember in 1996 when I published my first paper on the topic, and this is already 20 years ago, which makes me feel old, but on the other hand, for a field, it's nothing. In 1996, no one used the term transitional justice. It had not been coined. The referent, the sets of measures that I had in mind, of course, existed, and we thought about it already as a sort of policy. But there was no such thing, not such term as transitional justice. So in many ways, I would like to say a few things about what has been accomplished in the last 30 years. The second part of my intervention is not so cheery. It's about my perception of the challenges that transitional justice faces, and particularly of the challenges that it faces in contexts such as Libya. I stop parenthetically to insist what Elham already warned you about. I am not a Libya expert. And in this age in which expertise has lost so much respect, I want to emphasize that. I won't even pretend. Now, this may raise a question about why on earth did Elham invite me? But you may ask that question of her. I'm very happy to be here, nevertheless. And in the third part of the intervention, I will want to make some remarks about what I think can be done in the very difficult context in which transitional justice is now more often than not being applied. So that's the plan, and I will try to stick to the 30 minutes I was given. So first, an understanding of transitional justice. To put it very simply at first, I think that it is the set of measures that countries implement in order to come to grips with the legacies of massive and systematic human rights abuses. Now, around that general notion, one can elaborate it in many different ways, and I will do it here in terms both of measures, but particularly of the links between the different measures. So as it is very familiar, the core of a transitional justice policy is usually understood in terms of 4 different elements, the ones that were included in my ridiculously long title as a UN rapporteur. Alexander may remember, because he was kind enough to invite me several times for dinner at the Swiss representation in Geneva. Every time that I was asked to sign a guest book, I would have to say, do we have 15 minutes? Because just the title takes about 12. It's a ridiculously long title. You cannot have cards, business cards. You need a scroll. But it does have the advantage of being completely descriptive of what it is about. It is about 4 core functions that include truth, justice, reparations, and the other category of guarantees of non-recurrence, about which I will say a few things later in the third part of my introduction. Now, what I would like to stress more than anything in this first part is that those 4 measures do not form a random collection of initiatives, but rather that there are very important links between the 4 of them, and that is precisely what justifies the frequently made but rarely explained claim that transitional justice is a holistic notion, that it is a comprehensive policy, not just a scattershot set of efforts, but that in fact it makes sense to think about the measures in relationship to one another. There are 2 different arguments to defend the holistic nature of transitional justice policy. The first one is a very simple, practical consideration, and that is that if we are honest, and I think that we must, for a very compelling reason, that awakening expectations of people who have already suffered a lot without having a reason to believe that we will be able to satisfy those expectations is a peculiar form of cruelty. And I think we should avoid it. So we must be very honest about the reach of transitional justice measures. I happen to think that the field has not been very disciplined in this respect, that transitional justice has tended to overpromise and to simplify both the challenges that it always faces and the potential that it has. So I would like to start with a consideration that is actually part of the explanation of why it makes sense to think about the measures in relationship with one another, and that starts from the observation of the many ways in which individually transitional justice measures are somewhat weak. They are weak, and perhaps the best way of making the point is by starting by a descriptive claim. There is no country in the world that has investigated, prosecuted, and punished everyone that has been involved in massive and systematic human rights violations. None. There is no country in the world that has had a truth commission or any other truth-telling mechanism that has been able to disclose the whereabouts and what happened to each and every victim, or that has been able to clarify the many ways in which institutions have either participated in or enabled human rights violations. None. There is no reparations program established anywhere in the world that has been able to compensate victims in proportion to the harm that they have suffered. And finally, there is no country in the world, none, that has been able to reform all the institutions that, again, either enabled or participated in the violations. We ought to be honest about this. Now, I don't want to minimize the importance of this. My whole professional experience around transitional justice, I have tried to avoid studiously two extremes that I think are unhelpful in this domain. On the one hand, romanticism, the idea that simply by willing change in the world, it will happen. That the only thing that is missing in order to fundamentally transform the world is either clarity or goodwill or a combination of the two. I think that the world is much more complicated than that, and that romanticism in this respect is an unhelpful attitude. On the other hand, I also want to avoid being cynical. If I were cynical, if I didn't believe in the importance of transitional justice, I wouldn't have spent 25 years of my life working on this. So I believe that this is very important. I believe it is very significant. But of course, I do not believe that it is either easy or that it is a magic bullet that solves all the problems in the world. In fact, just as I have been interested in the linkages between the elements of a comprehensive transitional justice policy, I am very interested in the linkages between transitional justice on the one hand and other fields of policy intervention with which it seems to me it has to interact much more than it does up to this point. And those fields include development, social, economic, and institutional development, and also security. In the absence of both, transitional justice will have a significantly harder time. So the first argument about the linkages between the different elements of a comprehensive transitional justice policy is a pragmatic argument, because individually each of the measures is weak. It makes sense to try to achieve synergies between them because they can lend some support to one another. Now, unfortunately, we have now empirical evidence that this is indeed the case, that when the measures are designed and implemented in total isolation from one another, they are much less effective than when they are designed in relationship with one another as part of a comprehensive policy. And there are different ways of establishing that that is the case, including some sort of natural experiments in countries that have had experiences of the implementation of the measures singly and then comprehensively. And the very same countries show the difference in results when these are implemented as part of a comprehensive policy. Morocco, for example, is a very interesting experience that had two different reparations experience, one as a totally isolated compensation mechanism, and one in which the reparation was associated with the truth-telling mechanisms and with institutional reform initiatives. And despite the fact that the compensation in the second experiment, the quantum, the levels of compensation in the second experiment were lower than in the first, the degree of satisfaction and sustainability was significantly higher in the second. And that is an interesting piece of evidence about this. But it is not the only one. I will move, however. There is a second argument to show that there are relations, important relations, between the four different elements. And the second argument is more conceptual in nature. And it responds to a question that in many ways it is puzzling that we still have to ask in the domain of transitional justice. And the question is, what's the point of doing this? Why do we engage in this exercise to begin with? And I say that it is surprising that there is no obvious question or consensus, because normally complicated policies are policies with respect to which we are very clear of why we take the trouble. With transitional justice, this is still a point of debate. I have argued in the past that there is a sense in which reconstructively in the sense of trying to make sense of an already existing practice, like, for example, sociologists of law trying to give an account of why law develops and what is the point of it. Similarly, reconstructively, I think that there is something that the four measures share: truth, justice, reparations, and guarantees of non-recurrence. As a matter of fact, share not just one, but four different sets of ends, of goals. First, providing recognition to victims. Arguably, every time that we establish a truth-telling mechanism, a prosecutorial strategy, a reparations program, or we engage in institutional reforms with a preventive intent, what we are doing, partially, is trying to recognize victims, their reality, their existence, and not just in their status as victims, but in their status as rights holders. We are using these mechanisms as signaling devices to tell victims and others that human rights violations are not inconsequential, that we take them seriously, and that when they happen, it triggers state action. The second thing that we are trying to accomplish in doing transitional justice is to try to foster the minimum conditions of civic trust. We want, again, to use these four different sets of measures, amongst others. It's not a closed list, and we can appeal to others. But these core measures of transitional justice to tell victims that they can trust others, and particularly that they can trust the institutions of the state. So again, there are signaling mechanisms with a particular end in mind, the fostering of trust. Third, and arguably, I think that these are devices to strengthen the rule of law. Countries that take the trouble to establish these four sets of measures are also trying to signal to citizens and to their own officials that the rule of law is important, that there is a set of norms that the country considers to be absolutely fundamental, the violation of which, once again, triggers decisive state action. And finally, there is a fourth end that I think all the measures, all the transitional justice measures share, and that is to foster what in some contexts is called reconciliation. I prefer to use the term as seldomly as possible because I think it's freighted with all sorts of resonances that are positive in some contexts, negative in others, but that in any case, what it refers to ultimately, from my perspective, is a certain type of social coherence, a minimum type of social cohesiveness, the sort of thing that we mean when we say that, for example, we want people to feel part of a shared political project, and that the ultimate sense of citizenship, for example, is precisely that, to signal that we are all members in equal standing of a political project that we all share. I could elaborate on this account of transitional justice in detail, including, for example, to go one level of abstraction more and say what these four goals have in common. I think that they have in common two very important social mechanisms. All of them are mechanisms for norm affirmation, and all of them work, to the extent that they do, by their ability to articulate and to disarticulate social groups. But I will not get into the details. I just wanted, in the first part to offer a conception of transitional justice and an argument for thinking about it in holistic terms. Now, the second point I would like to make in this brief introduction is that this thing that we call transitional justice has accomplished a great deal in the last 30 years. And there are very different ways of seeing this. Transitional justice managed to achieve a normative shift at the international level in that brief period of time. And that is a tremendous accomplishment when one knows anything about how difficult it is to change norms internationally. 30 years is an instant for the sort of normative change that has led transitional justice to become totally normalized in the sense that it is one of the expected set of measures that countries that are undergoing transitions are supposed to consider and to implement. We would not be here were it not for the fact that this normative shift has taken place. And there are legal instruments to back up that claim. Legal instruments of very different kinds, from treaty laws to soft law instruments. But in any case, remember, what called us tonight was a discussion about the relevance of this concept to a country like Libya, which is in many ways very different from the countries in which the original understanding of transitional justice takes place. But nevertheless, a good number of Libyans, but also the international community, expects Libya, among other countries, of course, to implement what we now call transitional justice. And I think that this is a tremendous achievement. Now, it is an achievement that doesn't simply have to do with a change in norms. Transitional justice has made great contributions to the realization of those norms. So it's not just a question of entrenching abstract rights to justice, truth, reparations, and guarantees of non-recurrence. It's that the field has guided the operationalization of those rights, and it has given guidance about how those rights can come to life. Transitional justice, for example, has helped us understand how to cope with amnesties in the domain of justice, how to solve problems of retroactivity and prescription, how to think about a prosecutorial strategy for those contexts in which not everyone can be investigated and prosecuted. These are very, very practical ways of operationalizing the right to justice. The creation of truth commissions, of commissions of inquiry, and of many other truth-telling, truth-keeping, truth-finding, and memorialization efforts has given concrete content to what we now call, with perfect comfort, a right to truth. 30 years ago, no one would have understood what a right of truth meant to, except perhaps in a very visceral and abstract way. Now we know exactly what that means. And we know not just what the right means, we know how to satisfy it. We have a range of options about how to satisfy it. Similarly, transitional justice has made a huge contribution, not just to entrenching a right to reparation, but to entrench it in a particular way. Of course, the term reparations has a long history in interstate relations, but reparations for individual victims, victims of the state, for example, this is a novelty, and again, it's not just a textual novelty, it's something that transitional justice has taught us how to satisfy. Big, large-scale, massive administrative reparation programs, for all their faults, have given compensation of many different kinds to tens of thousands of people around the world. So I think that there's a lot that has been accomplished. The field can boast some great successes. So that's the end of the first part of my intervention. Now, the second part, of course, I said I am no romantic. So having talked about successes, let me talk about some of the real challenges that I think the field faces. Excuse me a second. All human rights work today faces some general challenges, as we all know. This is not a particularly good time for human rights. Let me mention three general challenges, not just challenges to transitional justice, but to justice and rights-related work, generally speaking. The first one is selectivity. There is a great deal of selectivity in the way that international human rights law is applied at all levels. And this is no secret, and I don't think that it requires much elaboration given time constraints. Not every country in the world is subject to the same sort of scrutiny with respect to its human rights record, and I think that this is a fundamental problem for human rights work. Secondly, the tendency to securitize issues, to interpret challenges as if they constituted existential threats that therefore justify exceptional treatments and departure from the rule of law is a huge, huge challenge to human rights work. The fight against terrorism all over the world, for example, constitutes a huge threat to human rights world, and not because terrorism doesn't need to be combated, but because in the name of the fight against terrorism, great abuses and great departures from normal rule of law expectations are justified, breaking all sorts of human rights standards. And third, the so-called closing of civic space, the fact that more and more countries are adopting legislation that restrict the way that people self-organize and the way that civil society organizations operate, placing them under very, very heavy regulatory and reporting burdens with a great deal of government supervision and in some cases limitations. I think that this is a huge, huge threat to human rights. But I want to now stay closer to transitional justice. I think that one of the fundamental changes that transitional justice faces is that it has acquired a very, very formulaic and technocratic character. And that one very easy way of seeing this is the fact that it is now being applied. The very same model is being applied across entirely different contexts. So a mini history of the field, if you allow me, would say what we now know as transitional justice, the model took shape in the Latin American countries of the Southern Cone. In other words, authoritarian states that were very strongly institutionalized. Strongly institutionalized broadly in the sense that the institutions of those states, Chile and Argentina, for example, had the capacity to make themselves present in every corner of the territory of those states. Of course, it doesn't mean that the government of Chile and Argentina provided the same services, for example, in Buenos Aires and in Patagonia, but not because the state could not, but because it chose not to do it. In other words, the institutions of the state were very broadly distributed. They were also very deeply institutionalized countries in the sense that these were countries with very few legal vacuums. Either the legislature or the judiciary or both had already expressed itself over, or expressed themselves over the fundamental issues that establish the relationships between citizens and the state. Now, the model took shape in that particular context also in response to a correlated set of violations, namely the violations that are typical of the abusive exercise of state powers. There are some violations that can be carried out systematically only with very strong institutions, not otherwise. Now, that very same model is now being applied, and we expect it to be applied in other countries. In countries that are very different from Argentina and Chile, very different from the Central and Eastern European countries that in many ways inherited the model, very different even from South Africa, after which the model was dispersed very rapidly. We expect the same model to work, for example, we expected it to work very well in Liberia and in Sierra Leone. And today we expect it to work the same in Yemen, in South Sudan, in Mali, in the Democratic Republic of Congo, in the Central African Republic. And those, I want to say, are very, very different countries from Argentina and Chile. And they are very different precisely in the two terms that I attributed to the authoritarian countries. These are not strongly institutionalized countries, either horizontally or vertically. The institutions of the DRC are not at all present in every corner of the national territory. These are countries with huge legal vacuums in which parliaments and courts have not spoken about everything that is of importance in the relationship between citizens and state institutions. And correspondingly, what needs to be redressed in those contexts are not the violations that come about from the abusive exercise of strong state power, but rather the violations that resemble or that come about much more from something that resembles social conflagration than authoritarian abuse. Now, the fact that we can travel from Santiago to Kinshasa, making essentially the same recommendations when it comes to transitional justice, is something that should give all of us some pause, because Kinshasa is very different from Santiago. And I want to say, as far as I know, Tripoli is very different from Buenos Aires. So the field has become formulaic in a way that doesn't help. Now, the difference between a post-authoritarian and a post-conflict country can be characterized in more detail. But just rapidly, it is, of course, an entirely different thing to make, for example, attributions of responsibility when you have a highly asymmetric situation of human rights violations in which the state, for instance, is responsible for 98% of the violations, as they were in Chile and in Argentina. In the post-conflict scenarios, you have a much larger number of agents of violence. The responsibility for acts of violence and violations is much more symmetrical. There is a great deal of circulation between the different armed groups, which themselves do not correspond to the model of a highly hierarchical, well-organized institution as a regular army. And therefore, making attributions of responsibility in a context like that is an entirely different sort of exercise. And if that is true in terms of making attributions of criminal responsibility, it is also true with respect to the functions of a truth commission, which made perfect sense when, for example, the abuses took place under the veil of secrecy, as they happened in the authoritarian cases, compared to the very, very open and public nature of warfare. or, at the very least, of open conflict, in which no one is trying to hide anything. Now, this is not an argument against transitional justice in the post-conflict setting, because I believe that fundamentally the only way to restore a sense of a shared community is precisely to come to grips with the past. But it is an argument for thinking very carefully about what is it that we want to accomplish when we implement transitional justice, and particularly it is an argument for thinking very carefully about the shape that transitional justice ought to take in contexts of that follow conflict. Let me just make sure. Yeah. So one more obvious consideration, one more obvious difference between the post-authoritarian and the post-conflict cases is that transitional justice measures in the post-authoritarian transitions were precisely that, measures applied after the transition had taken place. In the post-conflict settings, countries like Colombia, for example, by the way, where I was born, are countries that have tried to implement transitional justice as the conflict is still taking place. Almost without exception, however, post-conflict countries implemented the measures when there are still very, very significant security deficits, even if the countries had already signed a peace agreement. Sierra Leone and Liberia, for example, are a perfect illustration of this. An agreement had already been signed. Nevertheless, conflict and violence in many ways continued, and this poses a fundamental challenge to the operation of transitional justice measures. Witnesses are reluctant to share evidence. Victims are very reluctant to give testimony to truth commissions. Designing a reparations program when you do not know the full extent of the universe of victims is very, very difficult, because that's a universe that increases in size over time. And reforming institutions, particularly security institutions, in times of conflict is not an easy task, because in many ways the country still depends on the provision of services by these very same people that you are trying to get rid of. So these are very, very deep challenges that the new contexts pose. And I want to add a couple. The implementation of justice measures in a context situation is an open invitation to do something that kills the purpose of transitional justice. And that is, it invites the use of justice as a hammer to combat your enemies. So rather than an impartial exercise that tries to bring a community together, post-conflict justice has a special burden not to appear as an instrument of turn-taking. We were disfavored and harmed before. Now that we have power in our hand, we will use justice as a way to take revenge on our opponents. And I think that this is a very, very difficult to do, and that most countries that have been faced with this have found it difficult. So these are some challenges. Now, the third and final part of my intervention. What can we do? I do not want to send the message that weakly institutionalized post-conflict countries need to resolve their security and development problems before they come back to us to talk about transitional justice. That would be a totally disheartening message. It would consist fundamentally of the message that justice is a luxury that only the affluent can afford. And I do not want at all my argument to be understood in this way. I reiterate, I think that it is time to rethink the modalities of transitional justice, and I want to give a sense of what some of these modalities can look like, can consist of, in the challenging post-conflict, weakly institutionalized countries. There are several things to bear in mind. The first one is that this will be a long-term process. It will take time. It actually always takes time. One should not lose sight of the fact that the great progress that Argentina and Chile have achieved in the domain of particularly criminal justice has been achieved 30 to 35 years after their transition. That for the longest time, this was a very, very difficult thing for both countries to accomplish, with respect to which they had very, very few results to show. Now they do, but we tend to forget that time has passed. So in 2010, I was invited by the World Bank to take part in the articulation of their annual report, which in that year was about conflict and development. And by the way, I recommend it. It's the 2011 World Development Report, because I think it is perfectly relevant to situations such as Libya's. Now, the most interesting part of that report, from my perspective, is that the bank commissioned research on rates of institutional change. The bank had developed many years before, 15 or 20 years before, a governance index with 4 or 5 different measures about the quality of governance. And it had a numerical ranking of different countries around the world. But up to that point, it had never done a study of how fast countries can improve on their governance index. So it commissioned research to do that. Now, the results were the following. In order to take a country at the level of governance of Haiti, which at the time was pretty low and is still pretty low, not to the level of Denmark, because that will be a huge leap, but to the level of Ghana, a middle-income country with more or less decent functional governance. Based on the average of all the countries of which the bank had information, it would take between 25 and 45 years to take the country from Haiti to Ghana. Based on the 3 historical top performers, that is, the countries that transformed themselves more rapidly than anyone else, the average would go down only to between 17 to 23 years. These processes always take time. And I think that it is important for us to internalize the message, for the international community to be prepared to stay with countries throughout the long transformation, and for both government officials and civil society members to commit themselves to that. After having worked with the Moroccan Truth and Reconciliation Commission, they organized a national conference, and they invited me to this. So this was my last time working on the topic in Morocco. And I sent a message that I am still convinced that is correct. To government officials, I said, you should take every opportunity to act on behalf of justice and rights as if it were your last. To members of civil society, by contrast, I said, never think that this is the last chance. It is always a process. It is always a long-term process, and never, ever despair. And I think that this is the first thing I would like to say about the difficulties of transitional justice in post-conflict context. The second observation is one that should be obvious. Transitional justice is not a standalone policy, even if you apply it comprehensively, even if you establish the 4 different mechanisms. it always rests upon a much larger web of institutions, cultural dispositions, and it is therefore very deeply connected with other topics, such as constitutional reforms. So let me illustrate this point very briefly. I was very heavily involved in Sri Lanka in 2016 and 2017. That's a country that separated discussions about constitutional reform from discussions about transitional justice, as it normally happens, by the way, and as it normally happens with the support of the international community that separates this as if they were totally isolated topics. Support for each of them normally comes from different parts of ministries, different sources, and there is very little combined expertise. Now, I think that both projects suffer. In the case of Sri Lanka, there was absolutely no way to move forward without, for example, very deep reforms in the Office of the Attorney General. The Office of the Attorney General in Sri Lanka, like in many English countries where English law has had an influence, combines the function of the state advocate with the function of a prosecutor, investigating and prosecuting cases. Now, because of the peculiarities of the case, which actually are not so peculiar but rather widespread, the state advocacy function is taken much more seriously than the prosecutorial function. And that means that the Attorney General has zero incentives to make investigations against state agents for human rights abuses. Now, nothing will change in the transitional justice domain in Sri Lanka until that changes. But that requires a constitutional reform, and therefore should have been part of the constitutional reform discussion. Similarly, in the long term, the fate of Sri Lankan democracy, from my perspective, depends on thoroughgoing security sector reform. This is a bloated military, a bloated and slightly out of control intelligence service, and until both are placed under effective civilian oversight, there will always be a threat to civilian institutions. That also requires a constitutional reform. Now, constitutional reforms also depend for their sustainability on taking justice seriously. There was no possibility of a successful constitutional reform in Sri Lanka that concentrated exclusively on the issue of devolution of powers to minorities without taking seriously the fact that the Tamil minority in particular had very deep grievances, not just about the way the conflict was ended, but historically. The sustainability of a constitution as the expression of a shared political project cannot ignore claims, perfectly justified claims for justice of a large part of a country's population. So these issues are interrelated. And this is the second observation I would like to make. I know that this is a big issue in Libya. I think that the international community and many nations make the mistake of thinking that they face a dilemmatic choice. Either stick with an old, dysfunctional, undesirable constitution, or adopt in a rush an entirely new one. This is a totally false dilemma. Many countries have experimented with transitional constitutions. They include South Africa, for example, which for a long time had 34 principles that stemmed from the negotiation between the African National Congress and the National Front. And this was the constitution for a while. And it took years for the framing of a constitution that was subsequently adopted. And I think that the post-conflict countries should take this very seriously, because drafting a constitution in the midst of conflict is a particularly hazardous exercise. You have not only the same security concerns that we have talked about and that may have an impact on the transitional justice institutions, you do not have everyone at the table who should be at the table, and you do not have the conditions to think comprehensively about a constitution that truly embodies shared values and a vision of a political project that all citizens share and around which they can rally. So despite the fact that these are topics that are interrelated, they do not need to be resolved immediately. Now, a similar argument can be made with another argument that typically arises in the post-conflict situations about sequencing. This is a very old argument that first developed around not questions of justice in particular, but of democracy. So the old-style developmental theory in the 50s and 60s was countries first secure, guarantee safety, then they try to develop economically, and only then do they become democracies. The current version of that argument is you achieve security first, then you do development, and then you worry about justice. That is, once again, an argument on behalf of the idea that justice is a luxury that only the affluent can afford. And I want to say, it's not just that I find it morally objectionable, no? In the old democratic argument, it simply was tantamount to asserting that there were countries that were incapable of adopting democracy. In the human rights justice arena, it is tantamount to saying, again, come back and talk about justice only when you have all your security and development problems solved. It is also conceptually incoherent because, in fact, in order to guarantee security, ultimately, except for totalitarian states, security forces need the collaboration of citizens. They need to be trusted by citizens, because otherwise the only alternative is total supervision. So it turns out, similarly with development, we now know, is not just instrumentally aided by justice. Development partly consists of conditions under which people can exercise their justice claims. So the point I'm trying to make is that the sequencing argument is an oversimplification of a much more complex set of relationships between security, development, and justice. This is not, again, to take back the idea that there are important constraints that are placed on a transitional justice program by lack of insecurity. But it is an argument against the idea that justice needs to be postponed into the indefinite future. And I will finish, because I'm afraid that I have spoken for longer than I expected, with an additional set of considerations about things that I think can be done in the post-conflict situation in order to aid the cause of justice. The work of justice doesn't start with a transition. In Argentina and Chile, the work of justice was preceded by 20 years of efforts on the part of different civil society organizations to collect evidence, to build up files, to construct cases. I think that this is a fundamental but very well-known part of the topic. The work of justice is greatly aided by providing support for victims, and not just legal aid, because transitional justice is not simply criminal prosecutions, but there is a lot that can be done on behalf of victims. that is absolutely fundamental to the cause of justice. And not just because the victims deserve the care and the efforts to increase their well-being, but, for example, work on the topic of the disappeared, work on the issue of property restitution, work on psychosocial support for victims, are examples of things that will be very, very important for transitional justice down the line. And finally, two practical recommendations. I know no transitional justice program that has succeeded without a strong civil society. Governments, I have never met a government that says spontaneously, great, now we are going to do justice. Governments are pushed into justice efforts, and they are pushed by strong demands by civil society. So one fundamental question that I think all post-conflict countries should be asking themselves is, in the wake of the havoc that is left by conflict in terms of the disaggregation of civil society, what can be done in order to strengthen civil society organizations that may be individually very strong, but collectively quite weak? And therefore, for example, thinking about networks of civil society organizations, including, importantly, networks that can bridge some of the divides that are characteristic of conflict, I think is very important. And finally, and I apologize for the length, I think that we should never forget that significant and sustainable social transformation is not simply a project in institutional engineering, but that it also involves changes in terms of culture and in terms of personal disposition. So something that can always be done, that doesn't need to wait until the end of conflict, that can be done very actively and probably long before criminal justice measures can be implemented, is to think about cultural projects that, for example, explore the sources of social solidarity, to think about cultural interventions that strengthen the sense of tolerance, that think about something that I think we have lost, the ability, and that we lose particularly in the wake of conflict, to think about notions of the common good, and to be able to articulate arguments about a common good that can subsequently be codified in a constitution seems to me to be a pending and always pending piece of work, and one that can be done at any time. So in the end, despite the difficulties and the challenges that the post-conflict countries pose, which of course I do not want to minimize, I do not want to think or to convey the message that nothing can be done. It is very difficult, but it has been done, and I think that we ought to put much more efforts into it than we have, because in fact, most of the transitions today are not post-authoritarian, but post-conflict. Thanks a lot, and sorry for